I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. Today, we are discussing privacy and cybersecurity in Africa. Perhaps more than any other legal discipline, data protection is really a global legal practice. I've had many law students and junior lawyers come to me over the years and ask to do international law. And my advice is really always the same. Focus on data and technology. Why is that? Well, technology is only typically built once, and it's designed to have to comply with rules wherever it is launched. And data is, by its very nature, global. It moves globally. It's designed to move fast and cheap and trigger the laws wherever it originates, wherever it resides, and maybe in sometimes places in between. To understand that, we often think about data protection principles generally and then regionally. For example, what are the general data protection principles that cut across multiple legal disciplines? That is often helpful to kind of come up with a general rubric. But then more importantly, we start to dive in deeper into regional differences. What are the rules in the United States? What are the rules in the EU, China, India, so on? And in several places, I think the question maybe is formulated slightly differently. In some places, we actually think about the rules as a region. What are the rules in Asia Pac? What are the rules in Latin America or in Africa? And in some ways, those questions are actually misleading because there is not a single data protection law in the Asia Pacific region or in Latin America. Each of those regions have many countries, each with different rules. And on today's episode, we are going to be discussing what that looks like in Africa, but we'll take the bait. What are the data protection rules in Africa, and how is it that we can try to manage against those risks? To discuss that, I've invited a senior associate on our Paris team, Isatou Sila, to dive into the Africa data protection laws. She has been counseling international clients with Africa operations in the development of regional and global data protection programs covering Africa for a number of years. She's also leading a webinar on January 23rd with several of our Hogan Levels colleagues and the National Commissioner of the Nigeria Data Protection Commission, Vincent Olatunji. Isatou, welcome to the podcast.
Thank you very much, Scott.
So why don't we start by asking you a basic question? I think clients often are wanting to know, what is happening around the world with respect to data protection, including in countries where they don't spend a lot of time focusing their day-to-day. And that often comes up, what is happening in Africa? So let's start there. What does the data protection landscape look like in Africa today?
So the landscape is pretty advanced in Africa today. Africa started looking at data protection in the early 2000s. We had laws dating back to 2001, 2004. So it's pretty advanced. We have 54 countries in Africa, and 36 of them have data protection laws. So there's quite a few laws to comply with. And with GDPR being enforced from 2016 and then being enforceable from 2018, we've had a new wave of laws coming from English-speaking countries that we call Anglophone countries, like Kenya, like Nigeria. And those countries have more GDPR-compatible laws. So yes, I would say this is very advanced. And I would add as well that data protection in Africa is step number one to having a legal framework towards the digital transformation of Africa. Most African countries, I would say the vast majority of them, have a digital policy, which is a 5-year to 10-year policy for the digital transformation. Step one is to have a regulatory framework. Step two is to have the infrastructure. So step two has started because the regulatory framework is almost there. So yes, this is pretty advanced in Africa.
So it sounds like with this digital transformation initiatives within Africa, data protection is only going to become more important under the legal systems within Africa. And are you seeing kind of a corollary increase and focus on data protection as a component of those changes?
It is. This is key. This is the hot topic. This has been the hot topic in Africa for the past 4 to 5 years. So yes, this is taken very seriously. The authorities are given more and more powers. And I would add as well that as part of the digital transformation, we have a package. So we have data protection, but we also have electronic transactions and cybersecurity, cybercrime. Usually when you have a Data Protection Act, it comes with those other laws as well: cybersecurity, electronic transactions, cybercrime, and data protection.
Terrific. So, how are you seeing these laws being rolled out? As I'm looking in my experience in the area, is that there's actually multiple ways that these laws are documented and created, everything from specific statutes to kind of regional agreements between countries to constitutional related requirements. Give me a sense of how you think those categories of the types of laws that you see in Africa.
So what we have in general is, chronologically speaking, you have a right to privacy in the constitution. In most African constitutions, you have a fundamental right to privacy. Then you have some rights to privacy as well in the civil law and the criminal laws. And most countries that do not have a comprehensive data protection legal framework would rely on those laws. Then, after that, what we have seen in the early 2000s until now is the emergence of statutes, of acts of parliaments, or acts of the legislature creating laws on data protection.
Right. So maybe from your perspective, interested in how these laws compare with other legal data protection frameworks around the world, in particular, the European GDPR, because I think, many of our clients have done the work to comply with the
Yes.
EU's GDPR and are often looking to leverage all of that work to meet other global requirements. How different or how similar are the rules within countries in Africa to
Mhm.
that EU GDPR?
So I would say, if you look again chronologically, you have some laws that predate GDPR. I'll give you the example of South Africa. They have a data protection act called POPIA, Personal Information Data Protection Act, and it was passed in 2013, but became enforceable in 2020, which means that in 2013 it was modeled on the defunct Data Protection Directive of 1995. So we do have, I would say, maybe 30 to 40% of the African laws that are based on the previous or that are inspired by pre-GDPR EU law, which is again the 1995 Data Protection Directive. And then the latest countries that have data protection laws are more GDPR compatible. I would say the key difference in any event, the key difference that we have between GDPR and the African laws, which is relevant to organizations, to data processors and controllers, is that there's still an obligation in almost all countries, not to say all of them, to register with the DPA, the Data Protection Authority. There's an obligation to register with the Data Protection Authority, and oftentimes, in order to transfer data cross-border, there's an obligation to get the authorization from the Data Protection Authority. So I would say that's the key difference. Then we have also maybe 45% of African countries that do not recognize legitimate interest as a legal basis for processing personal data. I would say that's a key difference as well, because if you are an international company launching services around Africa, you will need to change the privacy policy depending on whether legitimate interest is recognized, and also you need to change the consent functionalities on that basis. So I think those are the key differences. Other than that, the structure of the laws is very similar to GDPR and also to the 1995 Data Protection Directive. You have in all those laws, or most of them, you have the general data protection principles that are similar. You have the legal basis. I've told you they differ a little bit depending on the countries. Then you have provisions regarding data transfers. You have provisions regarding right to information. The right to information is like GDPR. Data subject rights are more or less similar to GDPR. I would say that portability is quite rare in Africa. But the right to access is everywhere. The right to erasure, the right to rectification is everywhere in the African laws as well.
Yeah, I mean, that sounds like quite the list, and that sounds like a huge amount of work if clients were really starting from the beginning. Fortunately, from what you were describing, is that many of those concepts appear in other European Union or the United States or other frameworks. But I guess as clients are looking to perhaps scale their existing operations with inside of Africa to address the Africa data protection principles, from your perspective, are there areas where they would want to focus first?
Yes, I mean, consent is a big thing. Consent, cookies. What we don't have in Africa is, with a couple of exceptions, what we don't have are laws related to cookies. So if there is a general consent principle that would apply to cookies, so if we say that consent should be granted on an opt-in basis only, then that will apply to cookies. That's one thing to look at. There's also the rules regarding breach notification. If there is a data breach, how long do you have to inform the regulator? How long do you have to inform the data subject, the people whose data was breached? In the EU, it's 72 hours when it comes to the data controller informing the regulator and the data subjects. But we look in the EU at the seriousness of the breach. In Africa, we tend not to look at that. A few jurisdictions will take that into consideration. And also in Africa, oftentimes the deadline is much shorter. It's 24 hours to 48 hours, which also applies to data processors. So I think those areas tend to be more onerous. Direct marketing as well is something that needs to be looked at. Now, when it comes to the areas of enforcement, what the regulators tend to look at is registration. They look at registration often and they look at transparency. So the rules regarding transparency are the same, more or less, between the EU and Africa. But regulators are very keen to focus on transparency and they want to make sure that privacy policies are as complete as possible. And they will seek to have the foreign-based data controllers register with them because that's what the law provides.
Yeah, I mean, I think that data registration concept or the registration of the processing activities or the registration relating to international data transfers, I think is unique and new. And it sounds like that is one of the areas of enforcement priorities thus far with inside of Africa's data protection journey.
Yes, it is new. It used to exist in France. It used to exist in Spain. I remember when I was practicing back in the days before GDPR, that was really an area of big concern to most clients that we had because the processing time is too long. It's totally impracticable. Whenever you want to transfer data to get an authorization, this is difficult to comply with. But we have seen organizations having a proactive approach and discussing their way of working with regulators and explaining and having their way of working signed off. Because if you are based in Africa and you're an SME, a small to medium organization, and you have an application form to fill in explaining how you process the data and how it's transferred, that's very simple and potentially simple. But if you are a tech giant, how do you describe your processing activity in a form, like in a 3-page or 10-page long form? It's not possible. So there's this necessity to engage with the regulators. And also the regulators tend to have been appointed by the government or by the head of state. They might not all have the technical background to understand the description of the data processing activities. So it's really important to engage with them proactively and also maybe to look at alternatives to registration. I give you one example. Nigeria, before they had their Data Protection Act 2023, had a data protection regulation that was issued by the ICT authority. And under that regulation, there was no registration obligation. What was said was that if a company processes more than 1,000 or 2,000 data subjects' data, they had to file a report annually, but that didn't prevent them from processing. And in order to file that report, they needed to have auditors signing the report off. And those auditors were called data protection compliance organizations. So that created a whole ecosystem where those auditors had to be licensed by data protection authority / the ICT authority. They would get licensed, they would get trained on data protection, and that would decentralize data protection, that they would make it more accessible to everybody. And looking at the fact that Nigeria is the most populous country in Africa. So I think that was a very brilliant idea, because in reality, if in any country with more than 1 million inhabitants, if all data controllers had to register with an authority, the authority will cease to exist.
So I'm interested in how these rules are either evolving or adapting or addressing kind of some larger economic trends globally. I know that many economists, and I think it's already happening now, predict that Africa will be a significant priority over the course of the next decade or two, especially not only with respect to the market itself and entering in that market in the way that you were describing some of the tech companies, but importantly, also gaining access to the huge amount of human capital and human talent that exists in the region that may in some ways be an area that can offer competitive advantages. With that often means that you have global international companies who are employing individuals within Africa. How do you see these rules applying not only to the consumer data, but also to the employee data?
So they already apply, and I would say it tends to be more manageable when we're talking about employee data. So we do have a number of international companies with offices in Africa. What they tend to do is to have a local person that would deal with the registrations and compliance in Africa. This has not been too much of a struggle. And what would be challenging is where the presence is in all African countries. If there's a local presence in all African countries. But what we tend to see is that those multinational companies have a presence in certain hubs, which means that they need to comply with the laws of 2 to 3 countries. So I've not seen that as a major concern. The main concern really has been the processing of user data. But you've raised an interesting point. It is true that capacity building is also part of the digital plan in all African countries and also the African Union. And I know there is an ambition to be for some countries or some regions to host data, to provide some outsourcing services, and then the big question mark is what infrastructure do we have? To date, there are not enough data centers to host that much data, but this is in progress. They're being built right now. And second is cybersecurity. Cybersecurity is a big issue in Africa that needs to be addressed. And as long as the cybersecurity issue is not addressed, then no matter how many data centers we create, the trust level will still need to be built.
Yeah, and maybe part of that too is going to be another kind of area where I think gets lots of difficulty, or it's a really difficult area for international global organizations who are looking to go into new regions, and that is data localization. Data localization, was effectively the requirement to maintain either copies of data or the original data itself only within the country in which it was collected or generated. To what extent are there data localization requirements within countries in Africa?
So they are beginning to pop up. We have so I need to give you some context. To date in Africa, in most countries, if you meet a member of government and he gives you his card, his business card, you will see a Gmail address or a Yahoo address. So there's a strong need for governments to localize data, to have their own data centers for sensitive, critical data, critical government data. So due to that, there has been a very, very, I would say, lively debate on data sovereignty and on data localization. Some countries have gone as far as requesting 100% localization, as we have in Russia. This has been pushed back, and now, to date, to answer your question, Burkina Faso in Northwest Africa is a country that requests localization of health data. Kenya has a list of categories of data, some of which personal data, others non-personal data, and those data needs to be localized in Kenya. Zambia is a country that provides that by default data must be hosted in the country unless the minister in charge provides for exceptions. So we're seeing what we've seen as well, not only in Africa, we've seen that in Vietnam, we've seen that in Saudi Arabia, we've seen that the reflex is very protectionist, have a strong localization rule, and then after discussions and looking at the practicalities of hosting all the data locally, it is later decided that data can be transferred cross-border, provided that some safeguards are complied with or are put in place, such as adequacy, such as having a robust contract between the importer and the exporter. So we come back to European standards, I will say, apart from the fact that in many instances, we need to get the authorization from the Data Protection Authority.
So the Data Protection Authority, as you're mentioning at the beginning, is not only around the registrations of particular processing activities or the data protection officer, but for specific data transfers as these safeguards are implemented, those transfers themselves need the registration, and it sounds like end approval be in front of the local regulators before
Yes.
they can take effect.
Yes, and we've seen that in Europe as well. In France, for example, for any transfer to a non-adequate country from France, we needed to have the DPA, the Data Protection Authority's consent, and then sometimes you find ways to provide a list of categories of data, purposes for transfer, and then they will let us transfer the data to different countries that are having to reapply all the time, because that's more work for them. That's more work for everybody. It's just very difficult to comply with. And again, you're looking at a continent that has fewer data centers than the state of California. So you know that most of the data is going to be hosted elsewhere. So you know that whoever processes data is going to transfer data cross-border. So, which means that potentially, if the laws were to be complied with to the letter, all data controllers will need to register and we need to seek the authorization from the data protection authorities. And data controllers are not only legal entities, they're also natural persons. So it could be you and me if you really wanted to comply with the law, and that would become unmanageable. So we have that aspect, which I think and hope will change, because having had the French experience, it didn't work quite well.
I mean, it also sounds like this is going to be an area where those types of requirements may start to run up against the priorities that are set out within inside of this digital initiative. You know, the more friction that you're adding to that process, I think the more likely is that the overall initiative and the strategy behind it becomes at risk. Isto, I'm interested in your perspective on, you know, you started at the start of our conversation today, indicating there were 54 countries in Africa, and my guess is that, you know, all 54 do not present the same type of obligations with respect to data protection. Where do you see the particular hotspots, you know, those countries that are really leaning into data protection or creating a unique regulatory enforcement?
So the laws, I would say the countries can be divided into three, maybe two, three trends. You know, you have the countries that provide for, you can classify them between the countries that provide for legitimate interest, because that's a big thing. If I were to advise a client, I would really highlight those countries that that recognize legitimate interest as a reason for processing the data, and the countries that don't. Then you also have the countries that require an authorization to transfer data cross border, because that's very onerous. So I will divide them in those sort of groups. Then in terms of hotspots, the ones that stand out really is they stand out due to enforcement. In Africa, in West Africa, Northwest Africa, I would say, in the countries that are not hugely populated but have a similar culture, people tend to not be very, very litigious, which means that sanctioning is usually not the answer. So the regulators tend not to sanction, because that's really not part of the culture. The reality in those countries, if you look at Senegal, Mali, Burkina Faso, Niger, if you meet somebody, they'll know after 10 minutes of discussing, you will know somebody that you know in common, so it's very difficult to sanction people that you potentially know. So the culture really is not about sanctioning, it's about mediation, it's about discussion, it's about raising awareness. And this is what we have seen in that region, which means that the enforcement levels have been extremely low. Burkina Faso, I'm not aware of them enforcing or sanctioning or imposing a penalty on anyone. And the DPO has existed since 2007. But they're very active again in raising awareness. And then you have countries like Nigeria that are very populous. It's this most populous country in Africa. You have some Eastern African countries that have a slightly different culture, and then very, very happy to enforce, and they're very happy to sanction. So I would say Nigeria definitely, due to the fact that this is an African hub, due to the fact that due to the business opportunity, this is an African economic power, and the fact as well that they do impose important fines, and they have a very active enforcement activity. I would say that Nigeria is a hotspot. And the fine is a percentage of a company's turnover, like in Europe. So we need to be aware of that. And also Nigeria is one of the few countries that hasn't got an issue going after data controllers that have no legal presence. So they're very happy to serve companies that are based in the US, in the Silicon Valley, which is not the case for all African countries. South Africa as well. South Africa is a country that has a stronger enforcement activity when you compare to the other African countries. It's not as vigorous as Nigeria, but again, that's a hub, that's an economic power, and the regulator there is quite active too. So I would look at those two countries, and I would look at Kenya as well. Kenya have been very, very active, and they're also a country with very strong economic activities. So yes.
Yeah, great. It's super helpful. Um, how do you see the future of data protection law in Africa developing? Do you see that there's ever a possibility for a harmonized approach cutting across the continent in the way that the EU was able to do, or do you see that is not something that we can reasonably expect for the foreseeable future?
So yeah, I've heard many times in Africa. When I was in Africa, I've heard many times that Africa needs an African GDPR. I think harmonization is possible, but not a GDPR, not the EU model. Why? Because The African Union is not like the European Union. The level of integration is not the same. The African Union does not have sanction powers, does not have, it's not, constitutionally speaking, the EU, so they cannot create rules that will be directly applicable to all the countries. However, I do think that to a certain extent, the African laws are quite harmonized because they follow a few templates, and so the structure is more or less the same. Then if you look within the laws, there are a few changes. So again, to me, the key areas of harmonization would be consent, would be breach notification. I think there needs to be proper discussion regarding registration and authorization by the DPAs. I think as well that in order to harmonize African laws, that there would need to be maybe one or two countries taking the lead and showing success stories and being very active in the African networks of data protection authorities. And perhaps that will naturally create some harmonization or further harmonization.
Yeah, very interesting. Well, I don't want to leave today's podcast without talking about the webinar that you are going to participate in, I think on January 23, 2024. Do you want to give us a quick overview of the agenda for the webinar and how listeners may be able to access it?
Yeah, so we'll have a webinar on the 23rd of January this year, 2024, and it's going to be about data protection in the Middle East and Africa. So we have that region, Middle East and Africa. We will look at what the laws provide. We'll look at especially in Africa, we'll do a comparison between the key provisions that we expect to see in data protection laws. And it's going to be a bit of analysis, a bit of overview, and we would invite our guest speaker who will speak about enforcement in Africa. And that guest speaker is Dr. Vincent Olatunji. He's the commissioner of the Data Protection Commission in Nigeria. He has worked before at the ANITA, which is the ICT authority in Nigeria. So he has loads of experience in terms of enforcement, and what he's doing is really a continuation of his past work. So he has been investigating some large companies, and I think it'd be really interesting to hear him talk about the risk that some organizations not based in Nigeria are facing for not complying with data protection laws. So, and we'll talk as well about the Middle East. And in the Middle East, we have seen a new wave or first wave of laws on data protection in the past 3 to 4 years. And we have Dubai, Saudi Arabia, got Oman, Turkey is a bit older. We have Kuwait. So we'll have an overview of the laws in the Middle East as well.
Yeah, great. Well, it sounds like from your earlier conversation that Nigeria is one of the areas where you can expect increased enforcement or at least attention from a data protection perspective. So having the national commissioner on that on the webinar sounds like a great conversation to be had.
Indeed, yes.
Well, dude, thanks so much for joining today's podcast. Really great conversation, and looking forward to future episodes where we can dive deeper into the developments in the region or in specific countries. With that, I'm Scott Laughlin. This is the Data Chronicles, and those were your data points.